Welcome to Senate Utilities Committee. We have the beginning of a hearing today on Senate Bill 353, and we've got the proponents in the room today. We will have first a bill brief from Nick Myers from the Office of Supervisor of Statutes. And Nick, I'll turn it over to you to get it going.
Thank you, Mr. Chairman, and good afternoon, committee. The Senate Bill 353 would establish requirements relating to the construction and operation of wind energy facilities in the state, and also establish some health and safety requirements for that operation. First off, the bill would provide that no facility could be constructed in the state unless the setback distance from each wind turbine of the facility is not less than 10 times the system height, which is the height of a turbine measured from the top of the blade, or 1 mile, whichever is greater, from the nearest property line of any non-participating landowner, public building property, airport, federal wildlife refuge, public hunting area, or public park. So prior to the construction of any wind energy facility, the bill would require a developer to submit an application to the Board of County Commissioners of each county that contains land within that setback distance, so within that 1 mile or within 10 times the system height. In addition to any other reasonable requirements that are imposed by the Board of County Commissioners upon that construction and that development, a Board of County Commissioners would be required to approve of an application submitted for this development as long as the developer complies with, and in my memo you can see, and in the bill as well, the following requirements. So the developer would have to submit an application to the board, providing the contact information and also a detailed site plan for the facility. The developer would have to demonstrate that all applicable setback distances are met. They would have to provide written notice of that proposed construction to all property owners within any of those setback distances, and also publish notice in the official newspaper of the county. They would have to provide information and plans for avoiding, mitigating, and minimizing the potential adverse health effects, and ensure that the turbines will not produce noise in excess of 35 decibels measured at each property line. To measure this decibel output, a landowner under the bill would be able to contract for an acoustic noise measurement at the expense of the developer. And if the facility is found to be operating in excess of that decibel level at the property line, the developer or the owner or operator of the facility would have to take mitigation measures, in which it could include shutting down a facility until measures can be taken to reduce that noise level. If a proposed wind energy facility and development would include an industrial wind turbine, which is under the bill a turbine that's got a generation capacity of 1 megawatt or more, the developer would also be required to provide the following information to a Board of County Commissioners. So the developer would be required to provide a shadow flicker assessment that identifies the maximum as well as the hours per year that will occur at each residence, any educational facilities, workplaces, healthcare settings, public areas, buildings, and the developer would have to attest in this application that shadow flicker would not fall on any non-participating landowner's property, or that the developer would take action to block such shadow flicker. The developer would also be required to provide a description of the planned setbacks and how all the setbacks with those industrial wind turbines are adequate to protect the public from risks. Also, an assessment of the risks would have to be provided with an assessment of the ice throw, blade shear, and tower collapse, and how those risks can be mitigated and are planned for by the developer. A description of the lightning protection system for the facility. A description of the color and obstruction lighting that's required by the FAA and whether any hazard to air navigation is expected from the facility. Also, a complete decommissioning plan This plan would have to be prepared by an independent qualified person or entity with knowledge and experience in wind energy facilities. This plan would require the developer to secure adequate financial assurance to implement the decommissioning plan, and that financial assurance would have to be no less than 1/4 of the cost that it took to construct the facility. And it also has to be made accessible to the Board of County Commissioners for use later on when decommissioning is necessary. Additionally, the developer would have to submit a plan for fire protection, and finally an assessment of whether the facility will interfere with any weather radars. So after an application is submitted, a Board of County Commissioners would be required to hold a public hearing on the application within 90 days, essentially, after the publication of the notice in the county newspaper. If the board finds that the developer failed to comply with any of the requirements provided in the bill, the board would be required to deny the application, but the developer under the bill would be authorized to correct a deficiency and then resubmit an application. Under Section 2 of the bill, so that's kind of pre-construction for facilities going forward, Section 2 of the bill would apply to current facilities that are operating in the state. So Section 2 of the bill would state that those current facilities would be required to operate such facilities, the owners or operators would be required to operate such facilities such that no residential dwelling would experience shadow flicker under normal operating conditions. And if a resident does indeed experience shadow flicker, that resident could submit a request to the owner or operator of the facility to eliminate that shadow flicker that's occurring on the dwelling. And if the owner or operator does not eliminate or take measures to take care of that shadow flicker within 60 calendar days from that receipt of the request, the owner or operator would be required to discontinue the operation of that turbine until an inspection is done to verify that any mitigation strategies that are used to eliminate the shadow flicker would actually eliminate that flicker. And then finally, for current facilities, it would require that an operator of a facility be adequately insured to insure against loss or damage to persons or property that are within any of the setback distances that are provided in Section 1 of the bill, so the mile or 10 times the system height. And this insurance must be adequate to insure for risks associated with ice throw, blade shear, tower collapse, and then potentially any other damage that could be caused by the facility. Mr. Chair, I'd be happy to stand for questions.
Thank you very much, Nick. Committee, any questions? Senator Francisco.
Thank you, Mr. Chair. I have two questions. So the first is, do we have a definition for public park elsewhere in our statutes?
There may very well be a public park definition somewhere in all the statutes, but under this bill, we do not specifically define public park for the purposes of this at this time.
Okay, and then if there is property within the setback distance in more than one county, the applications would have to be made to both boards of county commission.
Yes, that is correct.
Any other questions? Seeing none, thank you very much, Nick. We've got 9 conferees today in person. We also have 31 who have provided written testimony. For sake of time, we're going to give each conferee 5 minutes to get as far as we can get. And I'm going to turn it over then first to Deborah Kramer. Deborah?
Senator Thompson, members of the committee, I stand before you today in support of Senate Bill 353, and here's why. Last spring, the Lebec County Commissioners held town hall-style meetings concerning RWE Renewables' proposed wind development. And after a few meetings, word through the grapevine was that RWE already had properties leased near Mound Valley, where I live. A record management report from the Register of Deeds provided this was true. And shockingly, that 18,000 acres was already leased. No notification was given. Confused by early leasing and concerned where they were located. With the aid of friends from Lebec County, the leases were identified on a county ownership map, and from what I saw, I could no longer stay neutral. RWE, knowing the risk associated with turbines, having projects established in Texas and Oklahoma without state laws in Kansas to keep them from doing so, lease bordering 3 of our smaller cities, near 2 of our USD 506 schools, on 2 sides of our little Altamont Lake, on 3 sides of the K-State experiment land, across the road from the Army Corps of Engineers, Big Hill Lake. They leased thousands of acres within 3 miles of the Kansas Department of Wildlife, Fish, and Game areas, and some of them bordering them, even though that department's statement on wind energy says to avoid adverse impacts of our species and the users of the wildlife areas. The department recommends that turbines not be sited within 3 miles of a KDWPT managed property area. They leased to a resident of Mountain Valley 1,479 acres. 159 of those acres borders the west side of our city, half the length, as close as 875 feet at one point from our grade school. Now, what is dangerous about this situation for the residents is when the school board takes no issue and becomes silent, when city leaders won't pass zoning, when county commissioners on the same page as wind energy are the ones deciding our health and our being in a setback distances. None of our small cities pass zoning. Mountain Valley City leader with the mayor on the same page of wind energy and family members on the council related to this resident chose not to adopt even a 1-mile setback protection, not for the city, not for the school. Lebec County had 2 commissioners on the same page as wind energy. Commissioner Brian Kinsey, who was later removed in a recall election, and Cole Prell, that ended up with a coma violation from a phone conversation that took place, and RWE was mentioned. 3 days later, Commissioner Cole Prell introduced the following, and Commissioner Kinsey approved the resolution. 500 feet from public roads and non-participating property lines, 1,600 feet from non-participating residents, 1 mile from incorporated towns, protecting residents in unincorporated towns 5,280 feet from turbines, and residents in unincorporated towns and rural residents 1,600 feet is not fair and equitable. Providing 500 feet distance from turbines for our state highways and our county roads is downright unsafe. Months later, under pressure, Commissioner Cole rescinded his resolution, and just as fast as it was voted in, it was voted out. And today, they just keep on leasing. We now have 21,000 acres leased, and we have no resolution. And the next resolution may provide equitable and fair setback distances, and it may not. But you can. You can assure that ones are established. I would like for you to watch this video, please.
Já fui teu com caralho. Ai, já com caralho. Ai, ai. Cala-te. Oh, velho, esta merda.
This is not just a Lebec County issue. This is a state of Kansas issue. My safety, our safety, the safety of the school children, the safety of those driving down the state highways or enjoying themselves at the Kansas Fish and Game, our state, don't need something like this happen. In your hands is before you a bill that will provide that safety. And there's more than enough evidence and research brought to your attention to support those distances.
Thank you, Deborah. We'll hold, I'll try to leave us a little time at the end for some questions. Next up is Gayla Randall. Gayla? You'll have 5 minutes.
Thank you, Senator Thompson and committee, for allowing me to present to you today. I'd like to start by reading the Kansas State Statute, Chapter 72, Section 74, Article 74-7284. The legislature hereby declares that the purpose of state government is to keep secure the constitutional rights of Kansas citizens to protect their health, safety, and welfare, and to otherwise serve the public need in the most economically beneficial and operationally efficient and cost-effective manner possible. Dr. Ben Johnson, who is a heart specialist, recently gave testimony in Madison County, Iowa on February 1st, 2022, that there is a health risk associated with turbines. It is called suffered annoyance. He also shared there are a large number of scientists who believe there is harm and credible risk in turbines being too close. He also goes on to say turbines have been judged by a government, has never been judged by a government agency as safe. He defines safety as protection from danger or potential risk. I hope that you will take his testimony, which I've asked Senator Thompson to share with you. I sent it to him at heart, because he is a more recent medical physician that talks about the health risks and the safety concerns. I support Senate Bill 355 because it offers non-participant protections from the abuse of wind and solar developers who appear to ignore the non-participant rights. Kansas statute addresses many directives to ensure the rights of Kansans are not abused, infringed, or repealed, with entire chapters focused on what these rights and processes are. There are 84 chapters, to be specific, and of those, there are chapters and statutes devoted to mining oversight, oil oversight, gas oversight, roads, bridges, and even statutes concerning commercial livestock parameters, which do share how many feet from a property line those have to be located. So there's already a precedent established that our role as citizens to bring to your attention safety issues in your statute 72 stipulates that is your obligated right, is to ensure those safety risks are mitigated. State level statute is vital to ensure that all citizen rights are respected and considered, as county by county zoning will not protect those that are living on the county lines. And that is evident in Marshall County, Kansas, and I'm sure it's evident in other places as well. The World Health Organization has confirmed by studies that anything over 35 decibels in sound in a consistent manner of noise has led to health risks, and as that increases in a number, that can lead to even more severe health issues. The 2019 study by the Journal of Acoustic Society of America states that 6,563 feet is what's needed from a turbine in order to mitigate adverse noise. Identifying turbine height in statute ensures that as they get larger in size, then also the setback is also increased. Some countries, including France and Germany, have established a 1 mile setback, which is 5,280 feet. But this recent study in 2019 says that's not far enough. Setback from property line must be happening not from homes, because non-participants are not giving their permission for their lands to be included in any of that setback. Solar and wind lobbyists and attorneys will likely be presenting to you in the next day or two. And they'll say things like, well, we can't do this because it'll kill development. We can't do this because it will mitigate some of the economic development projects that they have in the state. But what I want you to think about is, are they actually saying they can't do their work unless they infringe upon the property rights of non-participants? Because that's what it sounds like to me. It's time for multi-billion-dollar renewable-focused companies to understand all landowners in Kansas have equal rights to enjoy their properties, to be safe, to have their welfare insured. It's not saying they can't develop, it's just giving them rules that they have to follow like others, utilities and statute that you have in place. I implore you to pass out of committee and support Senate Bill 353. Thank you.
Thank you, Caleb. Next up, we have Terry Whitert, County Commissioner, 2nd District in Labette County. Terry?
Good afternoon, Chairman Thompson and committee. Thank you for letting me come here today. I appreciate the chance to testify in favor of Senate Bill 353. As you said, I'm a county commissioner for 2nd District in Lebec County. My past history has been a manufacturing manager for 35 years in private industry. We had numerous problems with situations, and we had many situations that was beyond our capacity to heal. So when those things happened, I began to ask for additional resources to help fix those types of problems. When I was in the manufacturing business, I felt very adequate at handling most of the problems that came down the path of manufacturing. So I began to look to the north, the counties north of me, which is Neosho and Allen counties, and began to look at the wind energy business that was going on in those counties. It seemed to me like there was lots of issues and lots of mistakes that was made. So I began to look at my own county in Lebec, and we, as it's been said, we currently have over 20,000 acres already leased. I felt very inadequate to be able to take on these problems just simply because it was being left up to commissioners to try and negotiate with these large companies. So I also began to talk to people in my county to find out their opinions. I found out real quickly that there was a lot of divide between the people that were pro-wind and anti-wind, and it was alarming to me. And I talked to the people that was anti-wind, and their biggest concern by far was the safety for their family, their children's, their school, and all the things that would be affected by these potentially being close to their residence. So I began to think about what might be a good solution to make all of this work with us already having 20,000 acres leased and what we might do. So I came up with an idea as in myself was called safe space, which I found out later it was called a setback. So I found the solution to the problem of being setbacks might be a solution to the problem. But my next issue was I don't believe I currently have authority to set a setback in place. I don't think it's in my capacity to set setbacks as far as negotiating them to satisfy the concerns that we have. So I go back to my manufacturing days and I asked myself, what did you do when you couldn't make a solution? I asked for additional resources. So that's why I'm here today, is I'm asking this group of people to help me with additional resources to come up with this solution. So Senate Bill 353 gives authority to county officials to set setbacks. It would give us the ability to protect those that might be affected and those that are concerned about their health and welfare of their families. I really support that, but I want to say this. I am not against the wind energy, but I am totally against large corporations coming into my county and trying to destroy it. I find that real difficult. I also want to say, talking to many people, there is lots of evidence available that the wind generation facilities really cannot be trusted for many reasons. I'm going to give three. One is the financial integrity. It seems to me like lots of things are promised and lots of things are not held accountable. So I find that wrong. Also, the setbacks that are created by agreements are way too close, some of them down to 600 feet. I think that's not acceptable. And the third thing is it's been talked about, is the standard operating procedure of leasing ground and then not recording them in a timely manner. That to me is a real difficult problem. But let me close with this. There is a chance for this regulation to be set in place to help establish setbacks for wind generation facilities. With this potential for safe space, I think the state of Kansas has an opportunity to assist my county and all the other counties to work with setbacks in dealing with the wind generation facilities. I would like for you to pass Senate Bill 353. Thank you.
Thank you, Terry. Next up, we have Aaron Popelka from the Kansas Livestock Association. Aaron?
Thank you, Mr. Chairman, members of the committee. I'm Aaron Popelka. I'm Vice President, Legal and Government Affairs for the Kansas Livestock Association. I appear here today because KLA supports 353, and I wanted to give you a little bit of background on how that came to be. We have a convention every year in December, and last year, Chairman, I forget the number of the bill, but you had a similar bill. And we asked our members, we had some very convoluted policy, and we said, you know, help us as your team at the Capitol understand what you want. And what they came up with is really simple, and it's in my written testimony. I'm going to take a minute to read it. It says, therefore be it resolved, the Kansas Livestock Association supports legislation to protect the private property rights of landowners adjoining but not participating in wind farm developments. I think that says it all, and it says why we support that. The other thing our policy also says, I neglected to put in the written testimony, is we also support requirements to have financially sufficient decommissioning plans, which is also in this bill. Much of the discussion at that convention centered on setbacks. And a lot of that, as we talk to our members, I want to be clear, our members have signed these leases. We're not against wind. Folks in that room had signed the leases. They're okay with it. They also know some of their neighbors didn't. And what happens is, as these things have developed, there are various tactics that are less than honorable that are used by landmen employed by wind developers. And I think the classic case would be someone's approached and they decide at that time, I don't want to enter in that lease. Maybe they just don't want it. Maybe they don't like the siting requirements. Maybe it's the price of that lease. So they say, no, I don't want to do that right now. Well, the wind farms, they typically have a spot they want to put this turbine, and so what they're going to do is find someone as close as possible to enter into that lease too. And that's fine. That's that person's responsibility or ability. I think the thing that's missing here, and I'm sure there's going to be some opponents tomorrow come up and talk about how property rights and how much everyone should just be able to use their property. And that's true. Our members would agree with that. We are very staunch supporters of property rights. There's a part of law that they probably won't mention called nuisance law. And that says that you're free to use your property as much as you want until it creates externalities that affect the ability of someone else to use and enjoy their property too. And that's really what's at stake here. It's not that our members don't want to see wind developments. It's that when we choose, for whatever reason, not to sign a lease, there's some level of protection, and I won't get into, you know, what exactly distance it is. I think we're open to looking at the distances because right now we really don't have anything. And I think the other thing I want to mention, and I believe Ms. Randall mentioned it, the livestock industry, we've had separation distances since 1994. Did they work great all the time? No, there's challenges. I help our members with sightings, but you can work through it. And one of the important things to keep in mind that's in this bill is those can be waived. It's clear in the bill that if you're it says non-participants. Once you become a participant, they can place that tower closer to your home based on that agreement. It's not saying these things can't happen. And so when I suppose some developers are going to get up tomorrow and say, well, this would just kill wind. Well, that's not true. We still site feed yards, build new feed yards across the state. We just have to be mindful, look for homes, and we give notice when we're coming within so close. KDHE requires that. I think that's what we're here to advocate for, and that's why we'd ask you to consider this bill and move it forward. So thank you, Mr. Chairman, and happy to stand for questions.
Thank you, Aaron. Appreciate it very much. Next up, we have Dennis Hedsky. Dennis?
Well, thank you, Mr. Chairman and members of the committee. It's a pleasure to be with you today, and I can't emphasize strongly enough how important this legislation is. I express my extreme thankfulness to Senator Thompson, who has worked tirelessly to generate multiple facets of the industry that we're discussing here and trying to bring some kind of balance into play that heretofore just has not been there. And I think there is a way to get there. And I think setbacks is probably one of the key issues that is at the core of everything that we're looking at. I think if you solve the setbacks problem, then you almost automatically reduce tension in communities where adjacent landowners that are not participants in a project have felt very, very harmed by the activity of adjacent properties that are participating. And so I think that this is a huge moment for the state of Kansas and for every county that's out there that does not yet have guidance in this area. And so I hope that you will very carefully deliberate the language in this bill. If you need to modify it, modify it. But I think at the end of the day, we need to leave this building this year with legislation that does apply to proper setback management in every county in the state of Kansas. And they don't seem to be able to do that on their own. And so the people that have spoken here today have certainly expressed themselves in terms of the importance of the state of Kansas becoming involved in the management of this very tenuous issue. And I recognize that certain entities are going to be opposing this legislation. You'll hear from them tomorrow. You'll continue to hear from them in days and weeks beyond that. And, you know, the term economic development seems to be one of the core issues that they reside upon. And I would just give you an example that I pulled out of the Topeka Capital Journal 4 days ago. An article was written by Patrick Miller. In the last 20 years in the state of Kansas, there are 560 full-time jobs that have been created by this industry. 560. My math says that's about 14 jobs per industrial site. So I think that argument fails miserably. And I just say that the harm that's being done, again, I'm going to reiterate, the real harm that is being done to landowners who are non-participants in these huge projects are being impacted in ways that we cannot even begin to understand. If you don't live there and if you don't have the up close and personal involvement, you just don't get it. So I want to yield the rest of my time to people that are following me. But again, Mr. Chairman, thank you very much for bringing this legislation forward. And I want to thank each and every one of you for listening to the testimonies and carefully evaluating the opportunities that we have here to resolve this very difficult issue. So I do rise in strong support of Senate Bill 353. Thank you.
Thank you, Dennis. Next, we have Lucas Heinen. Lucas?
Hello, Chairman Thompson and members of the committee. My name is Lucas Heinen. I'm a farmer from Evers, Kansas, and I'm too tall for this microphone. I want to thank you for the opportunity to submit testimony as a proponent of Senate Bill 353. I'll keep this short. Number 6 out of 9, a lot of the good points have already been made, so we'll just let those go, and my kids were starting to doodle back there. I am the face, in fact, we are the face of non-participating landowners. I'm not going to sign a wind lease. I'm not going to say my neighbor can't sign one, but I'm not going to do it. So I need some help. I need some help. We formed a group in Brown County to try and get some citizen action so we can take it to our county commissioners and see what they can do with it. Well, the county commissioners need help. They don't know what to do. In fact, we are tasked with finding an attorney to help our county commissioners deal with siting and setback issues for these turbines. And we're happy to do that, but we're out of our league. I'm just Joe Average, and our county commissioners are really good at what they do. And our county attorney, he's pretty good, but this is over our head. We're looking for some help at a higher level. You can play with billion-dollar companies. They'll answer to you. They steamroll us. So industrial wind, they're huge. Unless you're right up next to one, it's hard to really see the size and scale of these things until you're looking straight up. So they had Astra statue on the top of the dome here is 306 feet to the arrow. I read that on Wikipedia, so I assume it's right. It's close. 306 feet. These turbines are 328 is the minimum that I saw, up to 600 feet now. So that'll dwarf the size of this Capitol. And we've got to take that into account. If my neighbor wants to build one, if he builds one or she builds one, just, 500 feet across the property line, and I live right here, that's 500 feet is better than 0 feet, but it's still too close. Something there needs to be some sort of buffer. Again, I'm a farmer. I look at things in acres. I look at things in half-mile lines, sections, things like that. I can see the hedgerow a half-mile east of my house. I can see the grain bin on my neighbor's property that's a mile. And his grain bin, it's a 27-foot diameter bin, no big deal. It stands about 28 feet tall. It's 7 rings. That bin on the horizon, I mean, it still has a decent size. It's not offensive whatsoever. But that bin is, what, 1/15 of the size of a modern wind turbine. And that bin doesn't do this when the wind's blowing, you know, all day long. So I guess I'm just asking, really, I'm pleading for some help from this committee, from whoever does this at the state level, to help our commissioners, help our families, and I guess help preserve, I guess, my right to enjoy the rural Kansas landscape that I grew up on and that I'll pass down, and my kids will pass down onto their kids. So I guess that's it. And I do apologize too, the hoarseness of my voice. I don't really sound like this, but we had a high school basketball game last night, and Horton, they won. And it's terrific. That doesn't happen very often. So we were yelling and screaming. So anyway, I would be happy to ask questions too when that time comes, but thank you very much.
Thank you, Lucas. Next up is Jessica Gigastad. Jessica?
Chairman Thompson and members of the committee, my name is Jessica Gigastad. I'm from rural Atchison County, and I just thank you all for the opportunity to testify in favor of this bill. It's important because it offers protection to non-participating residents who don't want wind energy close by them. The landowners who wish to have a turbine have nothing standing in their way. The door is wide open to them, but us non-participators, as Lucas just said, are basically out there on our own. And if this bill passes, it would save relationships between neighbors. It would protect county commissioners from energy companies with armies of lawyers that they're just frankly not equipped to deal with. I come from a line of dairy farmers from Northeast Nebraska, and the Sandhills are my home. It's a lot like Kansas, areas of Kansas. There's rolling hills, and there's creeks, and there are gigantic cottonwoods up there. And unless you were lucky enough to grow up there, you probably wouldn't appreciate its subtle beauty. And it is just, I'm so sorry. It's just been completely overtaken by windmills. They are ubiquitous. They are everywhere you look now. So starting in 2014, the wind companies contacted many of our neighbors and friends. The Prairie Breeze 1, 2, and 3 facilities moved into Antelope County. And when I visit home now, it's vastly different. There are 118 turbines in Prairie Breeze 1, 41 turbines in Prairie Breeze 2, 20 in Prairie Breeze 3. And in neighboring Holt County, Grand Prairie LLC, in 2016, there were 200 turbines built. That's almost 400 turbines, and the area is completely overrun. And yet, as recently as this past summer, my parents were solicited to sign a lease with a wind company, and they are all around us. I just think enough is enough. I saw the glossy folder sitting on their desk, and it had the pristine white turbine against a green field, and it gave all of the benefits of wind turbines, and there was nothing about shadow flicker or how it could affect our cattle or our health or anything of that nature. So I'm just, enough is enough. So I am sincerely requesting that some limits be placed on these energy companies. Our county commissioners, they're, as Lucas said before, they're out of their depth. So please help us and represent your voters. We are not Goliath fighting Goliath. We're David and Goliath, and we're just asking for your help. Thank you so much.
Thank you, Jessica. Next up, we have Brian Coover. Brian?
Good afternoon, Chairman Thompson and committee. Several of the things I was going to talk about have been touched on, so I'll move a little farther, but let me start with the the beginning of my written testimony. My name is Brian Coover. I reside in southern Neosho County. I have an engineering degree from Kansas State University. I've served on the board of Twin Valley Electric Cooperative for 20 years. I've served nearly as long on the board of trustees for Kansas Electric Power Cooperative, a generation and transmission cooperative that provides power to 16 rural co-ops in eastern Kansas. I'm currently the treasurer of KEPCO. Several of the people that have got up and spoken to you have talked about the county's commissioners' need for assistance. In my written testimony, I talk about the fact that by the time the county commissioners know what's going on, the wind developer has spent millions of dollars in the county. In the Neosho County, the FAA filings were complete. The transmission filings were complete. Wells Fargo had been contracted to be the tax equity partner with Apex, and the entire operation had been sold to Liberty Empire 8 months before there was a contract with the county. At the point that sale happened, we hadn't talked about setbacks yet. The county first knew about this project in August of 2018, when Apex showed up at the county commission meeting and told them they had nearly 40,000 acres leased. They basically had ownership rights of 40,000 acres. They'd spent an incredible amount of money. They had a lot of obligations, and this project was going to happen. Someplace along the line, they offered 1,000-foot setbacks to a property line. They had an ice throw study done to find out, because we pushed them to a group of community members to look at that safety issue. They paid for an outfit out of Huntington. It was University of Georgia affiliation. They determined that these wind turbines, because their tip speed is 180 miles an hour, could throw ice or liberated turbine pipes almost 3,000 feet. From that, they decided to increase the setback to property 25 feet, because actually 1,025 feet is all they could do and make it fit in the project. There are 511 homes in the project footprint. A third of the acres that they have leased belong to 2 individuals, absentee owner individuals. 80% of the people live on parcels or in small towns, Thayer and Galesburg, that are small enough that they didn't get a chance to have an opinion, because their property wasn't necessary for the completion of the project. So there was no offer made to them. I mean, I think I know these people well enough to think that most of them would have struggled to take money. I mean, if you came to me and said, we have a public need and we have to take your property, I'd sell it for what it's worth. But if you say, I'm going to take your property by making it impossible to live there and compensate you nothing for it, it goes to the property value, the property rights that people here are talking about. There are wind turbines every direction from our home. The lights flash all night long. My wife and I wouldn't mind if you included the expectation for radar-activated lights. South Dakota does that. This project cost Liberty Empire $500 million. The cost to put radar-activated lights on it was just a little over $1 million. So less than 1/4% of the cost of the project would make a world of difference in being a neighborly operation, but that was too much money. They didn't want to spend that. Anyway, my written testimony gives the timeline of all of the things that had to happen prior to the commissioners even voting. Tomorrow, opponents of SB 353 will have a chance to tell you why they don't like it. The wind industry lobbyists will remind you that they only build on leased land. That's a true statement. Everyone they offered a lease to got to choose, But in areas with a dense rural population, there is no reason to offer most residents a lease if they can negotiate a short setback with county commissioners. Turbines are too big to place on an area smaller than about 40 acres. Unless the property is wanted for transmission lines or a crane path, other people, we're out of time.
Yeah, I'm sorry.
Anyway, I appreciate it.
Thank you.
Thanks.
We appreciate it. We're going to try to save time for, got one more conferee, Diane Novak, and then we can open it up to questions from the committee.
Senator Thompson and committee, thank you. Better? Thank you very much for allotting the time for me to speak before you. My name is Diane Novak, and I am a private citizen and a former Marion County Commissioner. I served on the commission for 4 years, from 2017 through January of 2020. It was during those 4 years that 2 wind projects came to Marion County. I know firsthand and have the knowledge and experience of what happens when you represent a small county trying to work with a multi-billion-dollar industry company with no requirements, no regulations or assistance on the state level. Unless you have a board of county commissioners who are actually savvy to wind projects, counties are sitting ducks. We are at the mercy of these companies. In Marion County, we do have a board of zoning, and we have full zoning in our county. But in 2016, our regulations were 100% rewritten and amended by and for the sole benefit of the wind projects that are now in Marion County. And how do I know this? In 2016, I was known as candidate Novak, and I was attending all the meetings I could possibly attend throughout the county, every planning and zoning, every commission, and others. As I sat in the planning and zoning meetings, I witnessed Diamond Vista, which is the wind farm to the north that has been in operation now since 2019. I witnessed their attorney and developers, Rex Savage, his attorneys, and other people hand-feeding our planning and zoning board all the changes that they needed to benefit and accommodate their upcoming projects. They would replace one word, maybe remove a sentence, rewrite a sentence, add a paragraph, take away a paragraph, or just went on for several meetings until finally in December 16th, the Board of Marion County actually, I brought with me a copy of the minutes from the Planning and Zoning meeting from December, and I'll read just one sentence from you, and it says, after discussion from staff and the public, it was decided to accept Tradewind's proposed amendments to our county. Article 27. It is now called the replace and repeal. They replaced and repealed all our existing regulations that we had in place to accommodate their projects. So I'm sorry. So this was the beginning of the woes for Marion County, because those changes that they made brought forth a lot of hate and discontent throughout Marion County. The last 3 years has been an actual nightmare. One of the changes that those amendments made allowed the wind farms to gerrymander the boundary lines. When they leased the property, it's very complex. I'll try to just go briefly. When they leased a acreage, let's just say an 80 acreage, they leased it, and so what they did was the lease should say that the leased properties within the leased lands is where the project would be built. But they actually said, well, we're not going to build on this section of the 80. We're only going to over here. So that will be the boundary within the boundary. I do have pictures, and I have more detailed if anybody would like to see that. But that sparked a whole lot of problems in Marion County, lawsuits. It just was all kind of neighbor against neighbor, the whole nine yards. So anyway, some of the other things right now in Marion County, we have 1,320 feet from a non-participating landowner's resident and only 500 feet from a property line, compared to the 5,280 proposed by this bill. On our decibels we have right now, we have an average of 55. And though they tell us that that is quiet, I got news for you, that is loud. And especially when they're 60. Some days when they're 40 or 30, it's a little better. But to get to that average of 50, we have all kinds of variations. And I know, because I do tend cattle in a pasture that has a turbine. So I can hear this turbine whoosh, 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 going like that constantly. It's absolutely horrible. I also asked the wind companies, what do they do with families that have children with autism or suffering from seizures? We have several of those families, but just nothing. There's nothing there to protect them at all. So then also I would like to say, I'm trying to get to these points real quick. Okay, so.
About 15 seconds, I'm sorry,
15 seconds.
Diane. That's
Oh,
okay.
no.
Just pick a good one.
Okay, well, I will just let you know that our residents were sued for $35 million from the wind company, only because they tried to exercise their right to protest these changes that were made in the wind farm. I also would like to say that when in the decommissioning, when they talk about the 4 foot, taking all that up, you know, some of that native grass has 15 and 20 foot root systems. So the 4 foot is not going to restore that ground back to the normal position. And again, my husband's a farmer, so I know about those root systems. And finally, on the removal of the, on the removal of the wind turbines, this is very important. It has been, I want to just say this, the blades and the repair of the materials removed from the county, they must be removed as an intact piece and cannot be cut at all, whether it's for transporting or anything. Carbon fiber dust has been identified as a carcinogen by the aircraft industry. Gotcha. So please consider that. Thank you so much.
Thank you, Diane.
I beg you to pass.
I want to give a little bit of time for questions. Thank you, all of the conferees. And again, there are 31 proponents with written testimony. Going to open up to questions real quick. Senator Pyle.
Thank you, Mr. Chairman. My question's for KLA. Aaron. Aaron, I've seen you on ag a lot over the years. I was on that committee. You're very familiar, I hope, with water rights. What's the setback distance if I drill a well to a water for irrigation? What's the setback distance for someone else to come in and drill? Do you know?
You're putting me on the spot. There is a distance. I don't know it off the top of my head, but it's to protect other local water users from that cone of drawdown. And if I don't know off the top of my head,
I'm thinking it's 1,600 and some feet, because it seems to me like it's the width of an 80 and quarter of a mile. So I mean, we might want to check on that. But I mean, when people talk about the rights and the property rights, the state entered in and took over the water years back before we were around, and they established rules to keep the peace, because they come up with junior rights, senior rights, you know all that. But I mean, it's just, when we talk about rights, and somebody mentioned something about your freedom, when your freedom ends where my nose begins. If you come in here with a pan of cinnamon rolls, I'm going to get some, that's just part of it. So, but I just was wondering if you knew that distance, because I know that helps to keep someone from impeding on your water right.
So, I don't know, and I'm happy to try and look that up and provide that to whoever to disseminate among the committee. But yeah, you are right. There are limits, and like I mentioned on the livestock, there's limits too. These setbacks aren't unusual throughout the law.
So to protect your rights as a water, it's even let's just say a domestic water right, which you have. I think property owner has a domestic water right pretty much. So how would one go about protecting a water right, a domestic water right, say if a rural water district or an irrigation is coming in and drilling wells? Do you know the steps that would need to be taken to protect that right?
I do, actually. So if someone came in too close, or you felt that your ability to use the water is being impaired, you would file an impairment proceeding with the chief engineer, Division of Water Resources at the Department of Agriculture.
Okay, thank you. So, and the reason for that questioning, Mr. Chairman, is the fact that, we hear, I'm a staunch advocate for property rights. Water was an issue that caused a lot of battle, if you go back and look at the history of it. But there are times when the state has to come in and develop the rules for play. And there are a lot of rules around water, a lot of them. And most of you have voted on some of those on the floor over the times when you've been here. And but domestic wells, you have protections, you have things in place the state saw fit to protect so that some bigger entity can't just come in and impede. So those are rights that are property rights also. And I don't know, I'm not advocating that the state take over the wind and own the wind, but anyway, it's just something to consider when you're thinking over this. Thank you, Mr. Chair.
Thanks, Senator Pyle. Senator Francisco?
Thank you, Mr. Chair. I had a quick question for Mr. Rapalka as well. And he can probably hear me as he comes to the microphone. So I just wanted to ask if the setbacks for confined feeding operations are measured from property lines or from like foundations of residences.
So they are measured from the edge of your pens to the edge of the house. It's not property lines. And certainly, Senator, I think that's one of those things that as the bill, hopefully if the bill moves forward, that's something that can be talked about. Because I think, property lines versus homes, there may be different distances. So I think there's a lot to talk about, but yes.
And then one other quick thing. I'm not sure that the bill really includes any opportunity to waive those setbacks in the same way that the confined feeding operations do. But if you can find that, show it to me.
Yeah, so I can real quick, is actually looking at that ahead of time. So on the first page, it says in section 1, A1, big A, non-participating landowners' property is what the setbacks apply to. So by becoming a participant, meaning you're leasing, you've waived your right to that 5,280 feet.
But if you're not participating, then you can't waive your right.
Right, yeah, that's how the waiver works. Similar with the confined feeding facilities, if we want to put it in and there's a neighbor within the distance, we go to them, instead of a lease, it's a form for them to sign, and then we file at the registered deeds.
I'm just saying it's different.
Yeah.
I have one real quick question, and then we're out of time. I think it was either Diane or Brian Coover with regard to the lawsuit. I think it was you, Diane. What's the status of that lawsuit, and what was the claim? Did they claim that they had a right to that property?
Okay, so the lawsuit actually was by the residents, and it was like 70 of them, the non-participating people. There were 70 of them who sued the county. They sued Marion County, but not for money. They sued Marion County to go back to planning and zoning and have our regulations and articles put back for their own safety and health. What happened was then at that time, Expedition Wind went to the courts and filed for it to be an intervener. And they filed to be an intervener because they said whatever the county does will trickle down to them. The courts allowed them to be an intervener. As soon as they got on there, they took over the lawsuit. They just filed the lawsuit, $35 million against the people. Well, then, of course, they started dropping like flies, and we were left with like 6 people still on that lawsuit. Ultimately, one of the lawyers found that there's a law or something called SLAPP. There's a SLAPP protection out there to where big corporations can't sue little individual people for these millions of dollars. And they applied the SLAPP, and that ended that lawsuit. So the judge also, we have a little bit of that still going, because the judge also then made Expedition Wind pay all those people back their legal fees, what they had to spend to try to protect their properties and their livelihoods. Well, then the judge got COVID. So there was one person who still has not got his money refunded, but these people were paying anywhere from $6,000 to $20,000 out of their savings to fight this mammoth lawsuit of $35 million. But that's where it's at right now. It's pretty much a done deal.
Thank you, Diane. Wish we had more time. Committee, thank you for your patience.